Thank you, Speaker, and I rise to indicate the opposition's support for the bill. Introduce our lead speaker for the opposition, and I'll make some brief remarks about it. And as I've referred in the course of debate, when from time to time there are opportunities to improve the criminal justice system's capacity to engage and to empathise, if I might use that word, with victims of crime, refer to the fact that South Australia for decades, going back to the 80s, has led the way in terms of law reform in this area. I pay particular tribute to Michael O'Connell in this regard, who was for a long time from I think 2006 to 2018, Victims' Rights Commissioner in South Australia, and very much had led the way, continues to do so in terms of an overall philosophical approach to the way that criminal justice system has at times through its history tended to alienate victims, and has gone through waves of development and engagement with victims that have taken on different forms through the decades, and I've referred to the sort of social advocacy and social movements that characterised the 60s and 70s through to the sorts of initiatives that we've seen in more recent times around access to involvement in the process of prosecution and capacity for victims to be heard in the court, including directly addressing perpetrators who are tried for their crimes. This is a discrete amendment in relation to the language that is used in describing circumstances in which an accused person will be dealt with differently by the court, the consequence of a finding of mental incompetence, and to make it clear to victims that the process of determining the facts has resulted in a finding of establishing what has occurred and explaining, characterising in a more empathetic way the reasons why a person who has been found not criminally responsible due to their mental incompetence will be dealt with in a way reflecting that mental incompetence, but in an endeavour to, as I've said now a few times in the course of this contribution, to create a means better to reflect the devastating consequence of those actions on the victims and those who are affected. It's been referred to in the course of the debate, and I note when the Minister read the government's speech into the Hansard that this follows on from advocacy of Michael O'Connor's successor in the role of Commissioner in South Australia, Bronwyn Kilmire, and I pay tribute to her service, and indeed that is carried on by the current Commissioner, Sarah Quick, and again I acknowledge, commend and thank Sarah Quick for the work that she is continuing to do in this area. I certainly hope and trust that South Australia will continue to lead the way in terms of the capacity of our criminal justice system more fully to engage, to empathise and properly to reflect the devastating circumstances that victims find themselves in. And in this case, while this might be in some ways carrying on from the good work of the New South Wales Law Reform Commission, there's plenty that can be done by way of cooperation. There are good forms of communication across jurisdictions. It's not always the case that we'll do things in a way that are immediately uniform across the country, and so leadership continues to be important in this space. I commend the bill and look forward to its speedy passage through the House.